Start up speaking about your firm, because your firm covers a lot of area within the real estate arena. Can you?
Yeah, that's right. Our firm, we are a real estate litigation firm. We do a little bit of transactional work, and we kind of have a few different branches because we have enough attorneys to kind of cover all the real estate areas. I personally do a lot of the property line disputes, Homeowners Association stuff, and also bad house cases dealing with real estate transactions.
Mm-hmm. And also, if someone needs to go to court, you have litigators as well.
Absolutely. We're in trial a lot. Just finished a trial last week.
There you go. And the name of your firm?
Law Offices of Peter Brewer.
There you go. Peter will like that.
Yeah, he will.
Okay. Let's get into the HOA situation, especially with litigation. Now, that could be between homeowners, neighbors, or the litigation involving the association itself.
That's right. There's oftentimes any of those three parties can be involved, and then once those parties get involved, also the insurance carrier can come in, which puts another wrinkle into the mix.
Now that means every party is going to have an attorney standing there or at the table, right?
That's right.
Okay.
In most cases, and in those HOA cases, it's oftentimes there's an attorney fee provision within the codes and covenants and restrictions for the Homeowners Association, so those attorney's fees actually really make a big difference.
Sure. Now you have mentioned, we spoke about neighbors getting along and cooperating in this building. There might be 10 units in this building.
Sure.
For instance, condos where there's somebody living below or above you. Mm-hmm. For instance, you mentioned about the gas line for
right.
a new stove.
Right.
Can you touch on that?
Yeah, well, HOA is a little bit different from just living in your own freestanding home because a lot of those utilities are shared. So
right.
for instance, if you have a gas line that you need access to do some work on,
yeah.
that gas line is probably going to be running through 2 or 3 different people's properties as well, so you have to work with them if you're going to put in a new stove, say.
Okay, I know from being involved in real estate, if you're adding an appliance, perhaps the pipe might have to get larger. If it's a 1/2-inch gas pipe, now
right.
it might be 1.5 inch.
Right.
And so that's going to have to go through all those units.
That's right.
Right.
And if it's going to have to go through all those units, you're going to have to deal with those neighbors and getting access through their property, whether it's through some sort of basement or some other access point. And typically the HOA set up a system that allows you to get that access, but that doesn't always necessarily mean your neighbor's going to be a good neighbor and comply.
Sure. Now in that particular case, one neighbor did not want to assist.
That's right. That's right. We had a case where our client wanted to put in a new stove, and sure enough, the city was going to require a different gas pipe to be run, and he was 2 units removed from the gas meter, so one of the neighbors, it wasn't a problem. They said, of course, get in there and do what you need to do. The city had permitted it and blessed it and all that, but the neighbor directly next to him said, you're not going to get inside my property to do this. And sure enough, that turned into a lawsuit and a lot of money over what seemingly is such a small issue.
Now, in that particular case, the neighbor that did not want to cooperate had to pay attorney fees.
That's right. At the end of the day, in a lot of these homeowner association litigations, you're required to go to mediation before you actually get into the full-fledged lawsuit.
Sure.
So we went to mediation in that case, and the neighbor that refused access, he was flat out wrong. Every homeowners association has these CC&Rs that you have to follow. One of those CC&Rs is oftentimes says you can access your other neighbor's units to get access to utility lines. And it took a while to convince him of that, but once he finally realized and he had a mediator tell him he was wrong, he ended up paying a big chunk of our client's attorney's fees for that.
Okay, that's a good point, because I know you've mentioned in the past that when you are buying into a condo or townhouse community, you need to read those CC&Rs.
Absolutely. There's just so much information in those CC&Rs that you really need to make sure you have a grasp and understanding of all the rules that apply to that community. The rules are so far wide-ranging that if you don't know what's in there, you could buy a home and realize this isn't a place that you can live. So it's critical to take a look and to read those CC&Rs. They could be intimidating. They're 40, 50, 60 pages, but there's some stuff in there that could really hamper your ability to live in that house.
Now, in terms of condo townhouses, again, we have spoken in the past, and it's really paint to paint. You occupy that unit from paint to paint, but the walls are owned by the association.
That's
right?
generally the case. That's correct.
Now, for instance, what's very common is a water leak.
Yep.
So if it's on the third floor from the roof, from unit to unit to unit, and in between the walls, can you touch on that?
Sure. That's a huge problem in homeowners associations and condos is that if, for instance, your upstairs neighbor has a leak coming from his washing machine, it's going to come through his unit, down through the common area, which is basically the wall in between your property and the guy above you, and then it's also going to come into your unit. So you have three different parties, that's the three parties we spoke about, all involved in this case now, because you got the person who caused the leak, you have the homeowners association's own property, which is that in between the paint essentially, and then you have the person that's below. And the person that's below is oftentimes going to be the one in the most trouble in these water leak situations.
And oftentimes somebody forgot they put on the water for the tub, overflowed the tub.
Sure.
Or the dishwasher.
Yep.
Now, in that particular case, it is the occupant's responsibility.
It is. Most times it will be tendered to an insurance company, and then the insurance carrier will be involved. The Homeowners Association also is going to have insurance, and that insurance carrier might get involved. And then you might even have to be, if you're the victim down below, your homeowner's insurance might cover that as well. But it's really dependent on some of the factors and whether the policies will pick it up or not.
Let's speak about the finances for HOAs. Speaking about reading the documents that a seller is supposed to provide a buyer in California.
Sure.
Now, before the recession, I know a lot of homeowner associations throughout California were light on their finances, short. And now, when the recession comes in, people, that's the first thing they stop paying.
Sure. And it's very common that, and now there's this whole new business that's spawned off of people not paying homeowners assessments, that all these companies do is go after and chase homeowners for assessments. But the bigger problem is that you buy into an HOA, and if they don't have adequate money, you might have to be paying for that in the future if a big issue does come up, like all the roofs need to be replaced.
Right.
If the HOA doesn't have enough money in its coffers to cover that, they're going to go require each owner in that homeowners association to chip in for that work, and that could be several $1,000s.
Exactly. Okay, now we get into, say, the suburbs, or for that matter, the rural areas, where we have single-family homes with a fence line.
Sure.
And oftentimes, they're doing construction, and there's a survey, and it's a foot off into one yard or the other.
Yep.
Can you speak to that issue?
Yeah, we're seeing a lot more of those disputes in the last, I'd say 6 to 8 months, and it's kind of a sign of the economy changing. The disputes have gone more to some of these more traditional real estate things where you get a sense that people now have a little bit more disposable income to spend to kind of fight about some of these things that weren't such a big issue when no one had any money to spend.
Yeah.
So what's happening is a homeowner will apply for construction permits to do some work, for example.
Sure.
And in the process of doing that, they're going to get a survey done because they need to make sure that they're within setback requirements and they're not encroaching on their neighbor's property or within setbacks. And when they do that, they get a survey done, they find their neighbor's property, their neighbor's fence is over onto their property 10 feet, 1 feet, whatever it might be. But that can make a significant difference when you're trying to do some new construction. It can halt the project. So those disputes are becoming a lot more popular and a lot more visible in our office right now.
Now, that also, another problem that we've heard about in the past is the tree.
Sure.
There's often a tree, and of course it's always somebody loves that tree and it's important to their property. You have also mentioned in the past about when a neighbor either accidentally or on purpose will kill a tree, and there's a dollar amount to that.
There is. It's a very difficult dollar amount to establish because you can look at it as a loss of utility of the tree. So if that's a tree that provides some sort of use for you, shade, blocks of view, it keeps your home cool. It's really hard to put a number on that, but courts have found that number to be in the tens and 20s and 30s of thousands of dollars.
Wow.
And so that's a significant cost. Then there's also an opportunity where you can consider it for the replacement value. So if you have a 50-year-old tree, what's it going to cost to go find a similar tree, take out that old one and put a new one in? That's a $40,000, $50,000 cost potentially. And in California, we have a law that says that in these kinds of situations, if you kill someone else's tree, those damages can be doubled automatically just by way of law.
Wow.
So all of a sudden, when you think you might just be taking down some roots or cutting a few branches and you kill the tree, your damages can be a lot more than you would have ever anticipated.
Sure. Because there are a lot of neighbors, they were just doing yard work, and
Right.
they were trimming the trees hanging over their side of the fence or trimming the roots, and that actually killed the tree.
Yeah, sure. You can do a hack job and go down there and chop down some roots, and all of a sudden you got a dead tree on your hands and a neighbor that's not very happy.
Right, and that's where you have an arborist, should always come out. It's well worth the money.
Absolutely. A lot of towns require you to have an arborist when you're doing certain tree work, and it can save you a lot in the long run.
And you always want to talk to the neighbor first. Oftentimes they don't even speak to the neighbor.
Right.
Right.
And that's where the biggest disputes come in, both when you're dealing with fences or trees. All it would have taken is you to go over, knock on your neighbor's door, say, hey, this is the plan. You can work something out instead of just doing it without discussing it. That's when the problems really arise.
And of course, when the trees went in, the fences were there, then they planted the trees. Here we are decades later, now that tree trunk is now on the property line.
Sure.
It makes it even worse.
Sure.
Okay. Now, in terms of the easements on property disputes, can you touch on that a little bit too? Because there's also utilities and right-of-way.
Sure. You know, a lot of times when you're buying a property, you want to really be looking out for what easements potentially run through the property. So part of the disclosures you'll get and part of the information you'll get as you're going through the closing of a property will map out some of the easements that there could be. So you might be buying a house that has some sort of public right-of-way where the municipality that you're buying the house in has a right to run some sort of line through your property, and you might not be able to develop anything on that strip of land. So it's all stuff that you need to be looking out for when you're going through the disclosure process and buying a house.
Okay, there's one of the escrow companies that I work with, Title, they have a brochure that says 21 reasons why you want title insurance. Okay, can you speak to title insurance and why that's important for our
Sure.
transactions?
There's different levels of title insurance and different kinds. There's a CLTA policy and there's an ALTA policy. The ALTA policy is a really comprehensive title insurance policy that would cover a lot of the things that we've just spoken about. So for instance, an ALTA policy can cover such things as encroachment. So you buy the house, you're real excited about it, you go in and start doing some construction, you find out that there is a neighbor that's on your property a few feet. Sometimes those policies will provide you some value, and you can get a recovery from the title company for that, depending on the kind of policy you get.
Right.
And that's one of the most significant reasons to have these policies, and the lenders are typically going to require them anyway. And it's just a matter of what kind of policy you get and what kind of protection you're going to find.
Okay. Now, one of the things you mentioned at the beginning of the show is you speak about disclosure issues, and for that matter, the lack thereof.
Sure.
Right? Most of the real estate attorneys that I've worked with over the years, they mentioned that 80 to 90% of the cases are failure to disclose, or bad house cases.
Right.
Right? Now, that said, so sellers, when they're selling residential property, they need to fill out a questionnaire, and there's a form here in California.
There is. The California required form is called the TDS, or the Transfer Disclosure Statement. That's something that when we think of a traditional real estate sale, has to be filled out by the seller. And that's the one that's required. Then there's also a second form, which, depending on what jurisdiction you're in, it's either the SSQ, the Supplemental Seller Questionnaire, or the Supplemental Seller Checklist, SSC, which isn't required, but it's something I would definitely advise any agent and any seller to have their clients fill out. Okay,
good point, because the one that's statewide runs from Mexico to Oregon, right?
Yep.
It's very generic.
Yep.
It's really just a page and a half, maybe 20 questions, very generic. However, when then they found throughout California that perhaps there's more issues about that property that we'd like to find out about. So when that additional questionnaire came out for the sellers, it's typically 1 or 2 pages. Now it's up to 9.
Yep.
Can you speak to what might be on there in terms of additional information?
Sure. Well, first, it's important to understand why that supplemental checklist is there, and it's really to protect you as the seller. So if you're selling a piece of property, that's not your time to advertise or to glorify the property. You're doing that to avoid getting sued later on. And so the great thing about the supplemental checklist is that it contains anything that's probably ever happened in a lawsuit that the creators of the form can think of. That was something that should have been or potentially should have been disclosed that wasn't. So the SSC goes through so many different things that trigger the sellers to think of things that they should disclose. So you might not think that a loud neighbor is a problem that needs to be disclosed.
Oh, good point.
But then when you start flipping through the SSC, there's a section that talks about that, and then you say, oh, well, you know, I guess that is an issue that I have. And so it gives really good real-life examples to really get you thinking about the things that you should be disclosing.
Now, typically these forms, they have to be filled out by a seller in their own pen.
That's right.
And it's always a good idea to be present with your realtor.
Absolutely. You know, it's just another person in the room to help you think about things. Because if you do it on your own, you might go through and you're kind of going through and you have a question, you say, so let me give you an example. We had a buyer buy a house, and there was a driveway that went to the back of the property, and it provided stairless access. You couldn't get to the property without going upstairs unless you went up this driveway. And so it turned out that the driveway wasn't permitted, and it was actually encroaching on the neighbor's property.
Uh-oh.
So we have a big problem here.
Sure.
And it was a situation where if they would have gone through the SSC carefully, there is a question that says, are there any encroachments? Or have you done any improvements? And that would have triggered them possibly to say, oh, you know what, well, I do know that that driveway goes on my neighbor's property, and I don't think it's a big deal because my neighbor said it's okay. But if you would have gone through the SSC, you would have noticed that and said,
Right.
well, okay, and if your realtor's there, you can ask them about that.
Sure.
And any wise realtor will tell them, you need to disclose that,
Right.
absolutely.
I remember when these additional questionnaires came out, a lot of the real estate community was in an uproar thinking, well, if we talk about this, no one's going to want to buy my listing, right? Conversely, if you disclose everything, now the buyer knows what they're buying.
Exactly. It is a little bit of a catch-22, but by the time you're filling out these forms, you already have a buyer in place who's motivated and wants to buy this property. And so it's not your chance to just sell the property anymore. You've got a sale in place. You're protecting yourself in the
Sure,
future.
Sure.
Because something as small as not disclosing a water leak could end up being a lawsuit that's potentially over $20,000, $30,000, $40,000. But then once you tack on those attorney's fees, then that number really rises quickly. And as you know, the California real estate contract, the standard contracts have an attorney fee provision. So you lose, you're paying the other guy's attorney's fees as well.
Okay, can you touch on that one more time? Let's
Sure.
the importance of that.
Yeah, absolutely. The standard forms, and pretty much all the forms I've ever seen in California for a real estate transaction, have an attorney fee provision in there.
Yeah.
So if you need to sue, either if you're the buyer or the seller, and you're suing the other party over that contract, something about that contract, such as a failure to disclose, and you go all the way through to a trial and you lose, not only do you have to pay your own attorney, there's a good chance you're going to be paying the other side's attorney because you lost.
Okay, that's a good point, because I was, some of the attorneys that I work with, they had a case about a leaky roof. It's about 10 years ago, and the buyer and the seller, they did not get a roof inspection, but it leaked at 2 spots.
Sure.
Over the kids' dining room table and the master bed in the master suite. And the sellers, when asked, do you have any leaks in your house? Or how's the roof? Is it watertight? And they spent an hour answering the question, and they wordsmithed it to say, in times of climate change, there may be some moisture appearing, right? Well, they lost the case and had to pay $100,000 in attorney fees, and the roof, big house, $100,000 in damage. So it's not a good idea to wordsmith these questionnaires to make it sound a little more attractive.
Yeah, you want to be honest, but at the same time, you don't want to editorialize too much. So the average person selling a property, they're not an expert on roof leaks or on plumbing or whatever the issue may be. So you want to put it in as plain of language as you can, and then also alert the buyers of the documents that deal with it so they can do their own investigation. They can call up the plumber, they can call up the roof guy and figure out for their own knowledge what exactly happened.
Okay, Simon, I know you have spoken about it's very careful when you're filling out these questionnaires, if there's been repairs made, not to say, we repaired it.
Sure.
In fact, how one
Yeah,
should...
what we get a lot is people say, we fixed it.
Oh, that's good,
and when
yeah.
you say we fixed it, that's implying that it's not a problem anymore.
It's better than new.
Exactly,
right?
yeah. So, you know, a buyer sees that, they say, oh, no problem, it's fixed. What do I have to worry about? Well, when you say that, you're basically guaranteeing the work of some plumber or roof guy that you can't do that. If they did a poor job and it seems fixed in the summertime because it's not raining anymore, but as soon as you sell the property and the winter comes and it's leaking like a sieve, then you have a serious problem there. And so what you should say is that there was work done on the roof, and you provide the invoices, you provide the contact info, and they can investigate it on their own. When you're saying something is fixed, you're essentially saying it's not a problem anymore, and that's exposing you to potential liability if it still is a problem.
What about, I know there's a lot of homeowners that are very handy, they want to do the repairs. And terms, by the way, a lot of these repairs come out of inspections. So let's touch on that too. So
Sure.
The home is getting ready for sale. Let's say the listing agent is top shelf agent. They go out and have a roof inspection, a chimney inspection, a property inspection, a termite inspection. Typically there's a lot of fix-its that can go around the house.
Yep.
And the homeowner would like to do a lot of that work. And in the real estate community, say, yeah, it's probably not a good idea. We probably should farm that out to licensed professionals.
Right. Yeah, absolutely. I mean, I think that's always the safest course of action because, you know, you're exposing yourself to more liability there, and that's not what unless you are a licensed professional, that's not what your livelihood is. And these licensed professionals can go out there and guarantee the job in some manner or fashion, and then the blame gets put on them if there is an issue later rather than it being put on you. Once the transaction is done, you don't want to be going back to this property and dealing with it again, and that's one of those kinds of things that's exposing you to that possibility. So
typically, again, if most of the lawsuits are buyers going after the seller, and they have those inspections on the table, what about when there is a suit and there's only inspections hired by the seller?
Yeah, the inspections themselves don't replace your duty to disclose. Yeah. So if, for instance, you know there's a roof problem and you still get a roof inspection done as the seller, and you just say in your supplemental questionnaire, see the roof inspection, that's not good enough because you're not disclosing everything you know. Your duty as a seller is to disclose every material defect about the property, not just to put that on someone else. So you can say, see roof inspection, but also you want to talk about the specifics that you as the seller are aware of.
Now, in terms of the buyer getting inspections, which I think is a good idea. In fact, I think it's best to, there's 2 chimney inspections, 2 roof inspections, 2, and so on. What about buyer inspections? Any comments on that? Yeah,
I think you're absolutely right that it's a good idea to have both. You know, you can never be too safe. It's the belts and suspender approach.
Right.
And in any situation, you could have one person give you one opinion and another give you a completely different opinion. Right. So just for that purpose alone, just a simple practical matter, as a buyer, you're again protecting yourself there, so you know what you're getting into. And if that inspection reveals some work that needs to be done, you could negotiate that with the seller and try to get some sort of offset from them to pay for that repair if it's agreeable.
During the sale process.
That's right.
You mentioned about the seller having to disclose everything. Now the agents have to walk through the property, right? And what is the duty there? That's
right. The agents have their AVID duty, the visual inspection disclosure. And that duty requires them to actually walk through the property themselves and note things that they see with the property. Just like with the sellers, this is not their chance to advertise and to make it seem like this great property. It's the time for the agent to protect themselves. Now, the agent doesn't want to, again, editorialize or give opinions on things. They just want to do as plain of a disclosure as possible. So a good example is if you're in the garage, for instance, and you see on the floor there's some staining. You don't want to speculate as to what it is and say there's mineral deposits in the garage. You just want to do a plain disclosure and say there's some efflorescence or there's some staining in the garage, because chances are the agent isn't going to really know what it is. Sure, he can guess, but that's not what their job is to do. Their job is to disclose what they see.
Right. And they shouldn't describe, they shouldn't say small crack
Exactly.
Minor crack,
Right.
normal crack and stucco. Do you see
Right.
a lot of that?
Yeah, again, that's a perfect example of editorializing or giving their own opinion. This isn't an opinion thing. Real estate agents are experts at one thing, and you have inspectors who are experts at another thing. So if you have a concern, you could suggest you go down to the city to look at the permits, or with the crack issue, suggest that you hire someone to look at this. But you're just doing a visual, what you see, and disclosing that. You're not expected to be an expert in all these different fields.
So each agent does have to walk the property and write down the red flags.
Both the buyers and the sellers, what they see. Yeah.
Oftentimes we see in there it says, buyers are advised to hire inspectors, which is not the purpose of that.
It's not the purpose of that, no. The purpose is to again, explain what you see. And it's not a bad idea if you see something to suggest to them, maybe it's in an email or it could just be on the disclosure itself, to go hire an expert. But it's really just your opportunity as an agent to walk the property, point out things you notice, and just give a plain vanilla description of what you see.
And that's a good idea because that's typically early on in the transaction.
Yep.
Right, the first few days. Simon, I want to thank you for coming out here today.
I appreciate it. It's been great having me here.